Swayam Prabha. Digital India. Educated India.
Section 52. Grant of patent to true and first inventor where it has been obtained by another in fraud of him. You will recollect there was a provision which we had seen under section 26 where in cases of wrongful obtaining or where the invention is wrongfully obtained from a person, the controller had the power to substitute the right owner as the owner of the patent, and that person who filed the post grant opposition seeking the revocation of a patent under the ground that the invention was wrongfully obtained can now become the patentee by substitution of his name in the register of patents. So that was a case where an applicant who filed for a patent and got the patent granted, but he was not entitled to it. The person who was the genuine owner of the patent could first file an opposition under section 25(2), get the patent revoked, and then ask the controller to substitute him as the owner of the patent. That was in the context of opposition proceedings. Section 52 is in the context of revocation. After a patent is granted, within 1 year, there could be a post grant opposition filed for revoking a patent. The consequence of a post grant opposition is revocation, because we had seen that in section 25(4), pursuant to a post grant opposition, the controller can revoke the patent. So the consequence of a revocation proceedings under section 64 and post grant opposition proceedings under 25(2), one of the consequences could be revocation of the patent, because we are talking about a patent that has been granted. Now let us look at 52. So the difference between section 26 and section 52 is that in 26 the revocation happens by opposition after the grant or post grant opposition. In 52 the revocation happens under section 64. Now let us see how this proceeds. 52(1), where a patent has been revoked under section 64 on a ground that the patent was wrongfully obtained and in contravention of the rights of the petitioner or any person under or through whom he claims, or where in a petition for revocation the appellate board or court, instead of revoking the patent, directs the complete specification to be amended to the exclusion of the claim or claims in consequence of the finding that the invention covered by such claim or claims has been obtained from the petitioner, the appellate board or court may, by order passed in the same proceeding, permit the grant to the petitioner of the whole or such part of the invention which the appellate board or court find has been wrongfully obtained by the patentee in lieu of the patent so revoked or excluded by amendment. So this provision is the same as 26. In 26 we saw that if the whole patent is wrongfully obtained, then the whole patent could be granted in the name of the opponent. In this case, again, if the whole patent is granted, instead of revoking the patent, the appellate board or the court can substitute the petitioner, that is the person from whom the patent was wrongfully obtained, as the owner of the patent. Now in cases where it is not the whole patent that is wrongfully obtained but only a claim, then the appellate board or the court can ask for the exclusion of those claims by amendment and and grant those claims to the petitioner, what has been excluded by amendment. So, there are two cases here. The first case is where the entire invention is wrongfully obtained, then the entire invention can be, instead of revoking the invention, the appellate board or the court, and when we see court here, it means the court where a claim for revocation is made, and we will see that a claim for revocation of a patent or invalidation of a patent can be made in an infringement suit as a counterclaim. So, revocation under section 64 can happen either before the appellate board or before a court which is deciding the infringement case. So, revocation can be taken as a defense for infringement. So, the two consequences, if the patent is revoked by the appellate board or the court on the ground that it was wrongfully obtained, if the entire invention is said to have been wrongly obtained, then the petitioner will be now shown as the owner of the invention. The appellate board or the court can permit the grant to the petitioner of the whole or such part of the invention, which means if the whole invention has been wrongfully obtained, the petitioner will become the owner of the whole invention. He will be now made the owner. If only a part of the invention was wrongfully obtained, then the appellate board or the court will order amendment of that patent, remove the claims that were wrongfully obtained and grant them to the petitioner. 52(2), where such order is passed, the controller shall, on request by the petitioner made in a prescribed manner, grant him 1. In cases where the appellate board or court permit the whole of the patent to be granted, a new patent bearing the same date and number as the patent revoked. 2. In cases where the appellate board or court permits only part of the patent to be granted, a new patent for such part bearing the same date as the patent revoked and numbered in such manner as may be prescribed. Now, for this to happen, the petitioner has to make a request under Form 12 to the controller. So, 52(1) talks about an order passed by the appellate board or the court. The appellate board or the court, in a proceeding where revocation was considered, instead of revoking the patent, grants the patent to the petitioner, the entire patent to the petitioner, or a part of a few claims to the petitioner. Now, with that order, the petitioner will have to approach the controller, because the controller is the person who maintains the register of patents, and the register of patents has to be corrected for the record to be set straight. So, even if the appellate board or the court passes an order in favor of the petitioner will still have to approach the controller to correct the record. Now, that is done by Form 12. Now, a question may arise. Form 12 is filed pursuant to A, B, C and D choices, pursuant to a proceeding under section 25(2), a proceeding under section 64, a proceeding under section 25(1), none of the above. So, Form 12 is always filed pursuant to a revocation under section 64. So, you cannot file Form 12 unless the patent has already been revoked, and we are not talking about a revocation by the controller, but we are talking about revocation by the appellate board or by the court. So, in cases where the whole patent is granted to the petitioner, a new patent will be issued to the petitioner bearing the same date and number as the patent revoked. The patent revoked, the number will remain the same, the date will remain the same, but the name will be of the petitioner, the name will be substituted. So, a new patent will be granted, but in the name of the petitioner, same number, same date, but the petitioner's name will be different. This is where the entire invention is obtained. In cases where the appellate board or the court permits only part of the patent to be granted, meaning which few claims which were wrongfully obtained to be granted, a new patent for such part bearing the same date as the patent revoked and numbered in such manner as may be prescribed. So, in this case, the date will be the same, but the number will be different. The name of the patentee will also be different. Now, you can see this as a similar analogy to what is happening in this provision will be instances where the patent office can divide an application. Under section 16, the patent office can divide an application, separate the claims into two different applications, grant them with different numbers. They will have different numbers. They will have the same date but different numbers. Here, because there were claims that were taken, the controller will have to do a similar exercise of dividing the application, but in this case, the owners will also be different. In a divisional application, the owner will be the same. Because there was more than one invention, the controller will have to separate it. Here again there is more than one invention, in the sense that invention belonging to different people. In section 16, there was more than one invention, because there we were talking about invention as being one invention. The rule is one invention per application. The applicant included two inventions in an application. Because there was more than one invention, the controller divided it. This we do not call it a divisional, because the divisional and the parent belongs to the same person. Here the divisional, but this is a kind of dividing. The claims are taken off and granted a patent. You can't grant a patent with just the claims. The descriptive part should also be there. So, that claim will get the benefit of the description from the other person's patent, and the patent will be granted having the same date. So, we had mentioned that in a divisional it is antedated, the divisional gets antedated. Here again, when you see the word such part bearing the same date as the patent revoked is again a case of antedate. The new patent granted to the petitioner bearing those claims, you cannot envisage a patent having only the claims. So, it is understood that it will also have a descriptive part, and the descriptive part has to be the same, like how the descriptive part description in a divisional will be the same. The only thing different in a divisional and the mother will be the claims. Similarly, here the only thing different will be the claims, but unlike section 16 where the applicant was the same person for the parent and the divisional, here the applicant will be two different persons. Provided that the controller may, as a condition for grant, require the petitioner to file a new and complete specification to the satisfaction of the controller describing and claiming that part of the invention for which the patent is to be granted. Now, if the controller is going to grant only the claim in the name of the petitioner, then the petitioner has to file a new and complete specification to the satisfaction of the controller describing and claiming the part of the invention for which the patent is granted. Now, the claims will be different, but the technology, the claims will be different, but what is disclosed, there will be an overlap between the earlier application and the application filed by the petitioner. So, the controller shall require the petitioner to file a new and complete specification to the satisfaction of the controller describing and claiming that part of the invention. So, the new application which the petitioner will have to file will have a descriptive part and a claim. The claim will be taken from the earlier part. The descriptive part, we can assume that there will be some kind of an overlap. The descriptive part cannot be taken from the earlier application because the earlier application belongs to another person. So, here the descriptive part will have to be freshly generated by the petitioner. 3. No suit shall be brought for any infringement of a patent granted under this section committed before the actual date on which such patent was granted. Now, the grant date will be different for an application that was filed originally and granted and the petition that was filed for revocation. Pursuant to that petition, if the patent is granted in the name of the petitioner, the grant date will be different. Let us look at subsection 2.2, what is highlighted. Now, the appellate board or the court permits only part of the patent to be granted. So, if the petitioner is granted a part of the patent, the petitioner cannot bring an infringement of the patent granted before the actual date of the grant, which means normally you can only file a suit for infringement after the grant. In this case, there were two grants. The first grant happened in the name of the person who wrongfully obtained the patent, and then the petitioner filed a revocation and it got granted in his name. So, there are two grants because first the patent, as it was filed by the person who wrongfully obtained the invention, the patent got granted. Then the petitioner filed a revocation saying that claim 4 and claim 5 should not have been given to him, it should belong to me, and the court says that yes, claim 4 and 5 belongs to you, and he approaches the patent office with form 12 asking the controller to grant claim 4 and 5 as a separate patent. The controller will say you file a fresh complete specification, description and claim, I will grant it to you. Now, that grant is going to happen in a different date. It is different from the earlier grant, which is now revoked. So, this grant, you can only file a case for infringement after this grant date. You cannot say that because the patent was already granted, because that patent was revoked in the sense that claims were removed and transferred to another patent. Now, a person who has the second grant or in whose name, who substituted or who has become the owner of claims 4 and 5 cannot make a suit for infringement based on the earlier grant. He can only make a suit for infringement after the date on which his name appears as the patentee. That is a fundamental rule. You can only make a case for infringement the day you become the patentee. So, the petitioner soon after revocation was not the patentee. He became the patentee only after filing form 12 and the patent office asking him to file a complete specification with the claims, and that resulting in a grant. So, in this case, understand that there are two grants. Subsection 3 says that no suit shall be brought for any infringement of a patent granted under this section committed before the actual date on which such patent was granted. So, if there was an infringement before that date, there cannot be an action on an infringement before the actual date of grant. Rule 79, request under section 52.2. In section 52.2, we had seen that a request could be made to the controller using form 12, and one of the prerequisites for using form 12 is that there should have been a revocation of a patent under 64. 79.1 states that a request under 52.2 shall be made in form 12 within 3 months from the date of the order of the appellate board or court referred to in subsection 1. So, section 52.2 requires a proceeding under 52.1, and 52.1 is nothing but a revocation action taken under 64, pursuant to which the appellate board or the court comes to a conclusion that rather than revoking the invention can now be given in the name of the petitioner. It can be granted in the name of the petitioner and shall be accompanied by a statement setting out the facts. So, what are the things required? The form 12 has to be made 3 months from the date of order. It shall be accompanied by a statement setting out the facts upon which the petitioner relies, and the relief he claims, and a certified copy of the order of the appellate board or the court. So, there is one timeline and 3 conditions. The timeline is 3 months from the order of the appellate board or the court. The 3 conditions are: 1, there has to be a statement setting out the facts. The petitioner will have to say what relief he claims, saying that the patent should be granted in my name, or saying that so and so claims have to be granted in my name as a separate patent. The third condition is a certified copy of the order of the appellate board or the court has to be accompanied. 79(2), where the appellate board or court has ordered the grant of a patent to the applicant only for a part of an invention, the new patent granted shall be accorded a number in the same series of numbers accorded to the complete specification accepted on the same day as the patent is granted. Now, when a part of an invention is granted, there is no doubt as to what happens when the entire invention is given to the petitioner. It will be renumbered and it will be given as a fresh patent. But when a part of a patent is granted, 79(2) states that the new patent shall be accorded a number in the same series of numbers accorded to the complete specification accepted on the same day as the patent is granted. This refers to the grant of the patent in the earlier case, because in this situation there will be two existing patents. One, the patent belonging to the person who wrongfully obtained, but only a part of the invention was obtained. The remaining part rightfully belongs to that person. And then you have the other part, which is now becomes a separate patent in itself. So, when a part of a patent becomes a separate patent in itself, then it shall be accorded number in the same series of numbers accorded to the complete specification accepted on the same day as the patent is granted, because the date remains the same. Because the date remains the same, it should have number in the same series of numbers accorded to the complete specification. So that is something which the patent office will look at.